A grand jury is a legal body that is empowered to conduct official proceedings to investigate potential criminal conduct and to determine whether criminal charges should be brought. A grand jury may compel the production of documents and may compel the sworn testimony of witnesses to appear before it. A grand jury is separate from the courts, which do not preside over its functioning. The United States and Liberia are the only countries that retain grand juries, although some other common law jurisdictions formally employed them, and most other jurisdictions employ some other type of preliminary hearing. Grand juries perform both accusatory and investigatory functions. The investigatory functions of the grand jury include obtaining and reviewing documents and other evidence and hearing the sworn testimony of witnesses that appear before it. The grand jury's accusatory function is to determine whether or not there is probable cause to believe that one or more persons committed a certain offense within the venue of the district court. A grand jury in the United States is usually composed of 16 to 24 citizens, though in Virginia it is composed of lesser numbers for regular or special grand juries. In Ireland, they also functioned as local government authorities. In Japan, the law of July 12, 1948, created the Kensatsu Shinsakai, much like a grand jury. A grand jury is so named because traditionally it has a greater number of jurors than a trial jury, called a petit jury. Origins. The first instance of a grand jury can be traced back to the Assize of Clarendon in 1166, an act of Henry II of England. Henry's chief impact on the development of the English monarchy was to increase the jurisdiction of the royal courts at the expense of the feudal courts. Itinerant justices on regular circuits were sent out once each year to enforce the king's peace. To make this system of royal criminal justice more effective, Henry employed the method of inquest used by William the Conqueror in the Domesday Book. In each shire, a body of important men was sworn to report to the sheriff all crimes committed since the last session of the circuit court. Thus originated the more recent grand jury that presents information for an indictment. The grand jury was later recognized by King John in Magna Carta in 1215 on demand of the nobility. The grand jury can be said to be celebrating its 800th birthday in 2015, because a precursor to the grand jury is defined in Article 61. The longest of the 63 articles of the Magna Carta, also called Magna Carta Libertatum, executed on 15 June 1215 by King John and by the barons. The document was primarily composed by the Archbishop of Canterbury, Stephen Langton, who is also the man who divided the books of the Bible into chapters and verses. He was a Bible scholar, and the concept of the grand jury may possibly derive from Deuteronomy chapter 25 verse 1. If there be a controversy between men, and they come unto judgment, that the judges may judge them, then they shall justify the righteous, and condemn the wicked. Thus the grand jury has been described as the shield and the sword of the people, as a shield for the people from abusive indictments of the government, or malicious indictments of individuals, and as the sword of the people, to cut away crime by any private individual, or cut away crime by any public servant, whether in the judicial, executive, or legislative branches.